case on our arraignment calendar is the State of Georgia versus Edrick Faust, SU 24 CR 0547. Mr. Cruz? Hey, Ruby. All right, we're first going to handle the arraignment. Again, this is SU 24 CR 0547. This case is also on our daily calendar for your motion for bond. Mr. Cruz will handle the arraignment first. Any announcement with regard to arraignment?
Yes, ma'am. Good morning, gentlemen.
Good morning.
Attorney Maya Cruz on behalf of Mr. Edrick Faust. Thank Mr. Faust for allowing me to stand with him today. We would waive formal arraignment, Your Honor. The only thing that we request is that the undercourt allows us 30 days from today to file any motions to mirrors that we may have related to the indictment.
All right, let's go ahead and get the not guilty plea first, and then we'll talk about timing.
Yes, ma'am.
I get you. All right, the not guilty plea has been entered, and Mr. Cruz, you requested, instead of the 10-day deadline, 30 days to file motions. Is that right?
Yes, ma'am.
Ms. Gonzalez, any objection?
We have no objection to that, Your Honor.
All right, I'll give you 30 days to file any motions and extend the timeline from 10 days. We're going to handle what is on the daily calendar now. That is Mr. Cruz's motion on behalf of Mr. Faust. It is a motion for bond. The determination of bail status has already been waived by this defendant. Mr. Cruz, this is your motion. You may proceed.
Of course, there's no objection. I recognize.
Of course. You can hand that to the bailiff. Okay, so let's go ahead and bring it up here. All right, you may proceed.
Yes, ma'am. Your Honor, I've also filed a motion that's relevant to this hearing.
I'll ask you to speak into that microphone, Mr. Cruz, if you don't mind,
Yes,
so we can hear you. Thank you.
I've also filed a motion that's relevant to this hearing. opportunity, Your Honor. The only thing I would ask, Your Honor, is that I respectfully request a bond to be set on our pending criminal offenses where we are charged with 1 count of malice murder, 4 counts of felony murder, 1 count of burglary, first degree, 2 counts of aggravated sodomy, 1 count of rape, 1 count of aggravated assault, 1 count of arson, first degree, and 1 count of possession of a firearm or knife during the commission of a felony. Your Honor, I gave case law to the court. I'll also share with the prosecution. And the first case I gave, Your Honor, is Coward v. State. That's 266 Georgia, 191. This is a 1996 case, Your Honor. I am on the left side of the page, the bottom last paragraph and the last sentence of the last paragraph on the left side, which states, and I quote, Your Honor, the defendant's guilt or innocence of the underlying charge is not an issue at the bail hearing, especially since the defendant enters the proceeding cloaked with a presumption of innocence. I'm skipping down 2 lines, Your Honor, on the right side of the page. The decision of the defense counsel, and the relevance of this case is here, to bring the extraneous issue of guilt or innocence into the bail proceeding did not conclude, and it goes on to a separate issue. But the purpose of this case, Your Honor, is, as within Your Honor's wisdom, guilt or innocence is relevant at the bond stage. That's Coward v. State. The next case, Your Honor, I provided Your Honor the court, is United States versus Salerno. This is a U.S. Supreme Court case. This is the second case in the case law provided to Your Honor. The site is 481 U.S. 739. And Your Honor, the language here is on page 8 of that case. Your Honor, on the left side of the page, the last paragraph, Division 3. And it states, in our society, liberty is the norm. And detention prior to trial or without trial is the carefully limited exception. We hold that the provisions, and this was speaking specifically about a bail act that Congress passed, similar to the statute that we have in Georgia. We hold that the provisions of pretrial detention in the Bail Reform Act of 1984 fall within that carefully limited exception. The Act authorizes the detention prior to trial of arrestees charged with serious felonies who were found after an adversary hearing to pose a threat to the safety of individuals or to the community. And this is the language I stress in the opinion, Your Honor, which no conditions of relief can dispel. The next case, Your Honor, is Jones v. Grimes. That site is 219 Georgia, 585. This is a 1964 case. Your Honor, I'm on page 2 or 3. On the third paragraph in the left column is section B in the middle. It states, excessive bail is the equivalent of a refusal to grant bail. And this is going to be our issue here because with the bond that we're requesting, Your Honor, we're asking that that bail falls within the 8th Amendment's requirement that bail not be excessive. The next case I have that I provide to the report, Your Honor, This is one of the more recent cases. This came out in November of 2021, so it's just 3 years old. This is Coleman v. State. This is 361, Georgia Appeal 901. And the language is on page 203. And this case talks about excessive bill, which is obviously equivalent to no bill at all. And then the court wrote on the left side of the page, in the paragraph that is indented, excessive bill is prohibited by the Georgia Constitution and cites to that provision, and the 8th Amendment to the U.S. Constitution. For purposes of the 8th Amendment, excessive bill is defined as bill set at an amount higher than an amount reasonably calculated, and this is the language that I'm stressing, Your Honor, to ensure the presence of the defendant. When fixing bill in Georgia, a trial judge's foremost consideration, and this is language stressed by the case, a trial judge's foremost consideration is the probability that the accused, in this case, Mr. Faust, if free, will appear at trial, and this language is also stressed, to a lesser extent. The accused's ability to pay, the seriousness of the offenses or offense, and the accused's character and reputation. A defendant who seeks release on bail has the burden of showing roots in the community, that the defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating. Your Honor, if you look at this same page, on the right side of the page, the first sentence, I'm on the last paragraph on the right side, and again the court writes, certainly we are not unmindful of the length of, in this case, Coleman's defendant, Coleman's pretrial detention, but the language I'm emphasizing is, and the presumption of innocence. The next case, Your Honor, that I provided to the court is a seminal case in our state. It's a seminal case in regards to bond hearings. It's Ayala v. State. And that site is 262, Georgia, 704. And Your Honor, I'm on page 103 of this case that I've used on the court as well as the state. And our highest court wrote, the purpose of pretrial bond is to prevent punishment before conviction and to secure the appearance of the person in court for trial. And then it goes through the four-part test of Ayala, Your Honor, which you're familiar with, ties to the community, but showing ties to the community through not posing a risk of flee, commit a felony, pose a threat to individuals in the community, persons in the community, property in the community, or intimidate witnesses and interfere with police investigation. And next, Your Honor, I'm going to page 203 in the second paragraph from the bottom on the left side of the page. The court states, in this state, Georgia, unlike many other states, the presumption of innocence has always remained with the person accused of a capital offense, even during trial. The absolute most fundamental premise of our criminal justice system is that a person ought not be punished for a criminal offense until the state demonstrates guilt beyond a reasonable doubt. Unless the right to bail before trial is preserved, the presumption of innocence is secured only after centuries of struggle will lose its meaning. The next case I provided to unreport in the state is Easy Out Funding v. State. That's 224 Georgia Appeal 706. This is a 1997 case. Unreport may notice at the top of this case there is a red flag. That red flag pertains to, just briefly, notice there's a subsequent case that came out related to a bills, bonds, and obligation if that bills, bonds did not receive notice of a hearing within 72 hours. So that red flag is relevant to the purpose that we're quoting this case for. What we're quoting this case for, Your Honor, and the reason we have this case, provide this case to the court is because we are asking for home confinement for Mr. Faust. On the right side of the page, in the middle paragraph 2 or 3, and it states, it is further assumed that appellant who is taking a financial risk, and in this case, just for clarity, the appellant here is the funding, and we have a funding company that is willing to be responsible for Mr. Faust's fund. It is further assumed that appellant who is taking a financial risk in ensuring the defendant's presence at trial would be motivated to keep track of the defendant's case and to prevent the defendant's flight or relocation until the surety is relieved of its bond obligation. Such risk of flight is inherent in the criminal justice system, without which there would be no need for bail bonds or bond sureties. And as I mentioned earlier, we have a funding company that is willing to take on Mr. Faust's fund, the court is inclined to give Mr. Faust's fund. The last case that I provided this on the court is Brown v. State. This is a 2012 case, Your Honor. The site is 314 Georgia Appeal 1. This is a 2012 case. And the pertinent language that I'm citing is on page 2. It's the right column on the right side of the page, Your Honor. It is the third paragraph at the top. And the appellate court wrote, the General Assembly, which is our General Assembly, provided for the creation of programs of electronic pretrial release to, amongst other things, to assist sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release and monitoring, and this is stressed in the case, and home confinement, which is language being stressed. Indeed, the General Assembly found that a program of electronic pretrial release, monitoring, and home confinement, which again emphasizes in the case, incorporates modern technology to accomplish various purposes. Thus, the General Assembly explicitly recognized a defendant's home as a place where he or she can be kept within the bounds or restricted in movement for purposes of the electronic pretrial release program. And again, Your Honor, the reason I provide Your Honor for that case is because that is what we will be asking for in this case. And with that being said, Your Honor, that is the premise of the law that Mr. Faust wanted to share with his own reporters. I would like to call my first witness with permission.
Go ahead.
I would like to call Ms. Shaquita Thomas.
Yes, so if you'll have a seat, please stand, please. Thank you. Mr. Cruz, you may swear in.
If you please raise your right hand for me. Do you swear and affirm that the testimony that you're about to give before this honorable court is the whole truth, nothing but the truth, so help you God?
Yes.
And Your Honor, may the state and I approach on the matter briefly?
You may. There has been an objection to video coverage of witnesses on the stand. The state has not objected to this resolution, and the media coverage. And that is a representative from, I believe, Court TV, who is here today, has agreed not to publish the faces of any witnesses on the witness stand during any recording that they make. Mr. Cruz has made a presentation as to why that is important for him and his witnesses, but based on the agreement by the state, and of course the agreement by Court TV to accommodate all parties, I'm going to grant that wish. And that will simply be for anyone on the witness stand for both parties. Mr. Cruz, you may proceed.
Yes, ma'am. Just for purposes of the record, I'd just like to state that Ms. Shaquita Thomas, who was called, because and none of the court knows, none of us had notice regarding cameras in the courtroom for Mr. Faust's case. She has declined to testify
All right.
on behalf of Mr. Faust.
Do you have any other witnesses?
I do.
All right, go ahead.
The next witness, I intend to proffer testimony of Ms. Sherry Eberhardt. However, if the honorable court or the prosecutor has questions for Ms. Eberhardt, she is present. Ms. Eberhardt, would you please stand for me? Thank you, Your Honor. Ms. Eberhardt is present. Ms. Eberhardt is one of Mr. Faust's.
You may be seated. Thank you. Go ahead.
Ms. Eberhardt is one of Mr. Faust's closest friends, Your Honor. She's 61 years old, and she has known Mr. Faust since 2005. She was born and raised in Georgia, and she currently resides here in Athens, Your Honor. Before she was disabled, she spent 34 years with Baker and Taylor, and I understand Baker and Taylor to be the largest supplier of academic library content in the United States, in our country. Before Mr. Faust's arrest, when I asked regarding how close are they, she stated that he stopped by virtually every other day, parked his truck, stopped by for a quick chat, and they'll talk. Ms. Eberhardt will testify that Mr. Faust owns a successful car washing business here in Athens, Georgia, and she has never been arrested, Your Honor. Excuse me, she has never been arrested or convicted of a crime, and she is aware of Mr. Faust's criminal history, which the state will provide you with. With this knowledge, Your Honor, in regards to the Ayala factors, Ms. Eberhardt will testify favorably on behalf of Mr. Faust. She would advise on the court Mr. Faust would not flee if this honorable court was to grant Mr. Faust a bond. She will tell Your Honor that Mr. Faust has been arrested. He's been arrested previous times, multiple times. However, he has never fled. He has never fled the court's jurisdiction, and he's dealt with all of his criminal acts to conclusion. She would testify that Mr. Faust would not commit a felony if granted a bond. She would testify that Mr. Faust would not pose a danger or significant risk to the community or individuals in the community if granted a bond. And she understands the basis for that, from what she explained to me, is that he's been out in the community. He's been out. He hasn't, he's had arrests, but he's been out in the community. Mr. Faust will not intimidate any witnesses or interfere with the police's investigation of this case if granted a bond. And Ms. Eberhardt will tell Your Honor that Mr. Faust, before he was in custody, he would serve the community. He provided jobs. She explained that there's a crime problem with the youth, and Mr. Faust will take these individuals and keep them out of trouble and provide them jobs with this pressure washing business to keep them away from street crime. Your Honor, Ms. Eberhardt isn't just saying this, she's actually willing to be responsible and sign Mr. Faust's bond. That's how much faith she has in Mr. Faust, Your Honor. The next witness I have, Your Honor, to testify is Ms. Linda Thornton. And Ms. Thornton, if you would, please take a stand. Sir, if you would, please raise your right hand for this honorable court. Do you swear and affirm that the testimony that you're about to give for this honorable court is the truth, the whole truth, so help you God?
Yes.
Thank you. Can you please state your name for the court reporter?
Linda Thornton.
Could you spell that for us, please?
Last name?
Both names.
Okay.
Thank you.
LindaThornton.
Thank you so much.
You're welcome.
Ms. Thornton, have you ever been arrested?
No,
Have you ever been convicted of a crime?
no,
Can you tell this on the report, are you currently employed?
yes,
And where are you employed? You don't have to say your job location, but what city is your employment?
state of Georgia,
How long have you been employed with your employer?
3.5 years.
And what's your job title?
I'm assistant plant manager.
And do you know Mr. Edrick Faust?
Yes.
How do you know Mr. Faust?
Well, I first met him through his stepmom about maybe when he was 17, but I just knew him socially, but in the last 3.5 years, I've been knowing him personally.
What is your relationship to Mr. Faust?
I'm his fiance.
Can you tell on the report where Mr. Faust was born and raised?
Okay, he was born in Elberton, but he was raised in Overthought.
And where does Mr. Faust reside when he is not in custody?
In Washington, Georgia,
And how far is Washington, Georgia from that?
about 35 miles.
Can you tell us about Mr. Faust's profession?
He's have a pressure company that he wash cars, pressure wash, and he's been had the company like 7 years.
When you say he had the company,
He still has the company. I said have the company.
as the owner,
Yes,
does Mr. Faust have any involvement in the community that you could tell the report about?
yes. He always tried to help the elder people. When he's washing like maybe 3-4 times a month, some of the elder people in the neighborhood that he grew up in, he'll wash their cars free. And also, if they need something moved, or he'll help them with lawn work or anything like that. Also, he does try to help the youth out if they're not working in his old neighborhood. He may hire them a couple days a week.
Yes, ma'am. And then is it fair to say you're a bit nervous right now?
Yes.
If you would do this for me.
Okay, my voice is hoarse because I have sinus.
Yes, ma'am. It's okay. Slow down a little bit for me. Court reporter is getting everything you're saying.
Okay.
When I ask you a question, you just pause for a second.
Okay.
Just let the butterflies spread out a little bit. Into that a little bit. Okay? You say 3.5 years you stayed out of conflict. I want to make it clear. Have we had any felony arrests or any felonies take place in the last 3.5 years?
No,
Okay. Now, you mentioned you knew him at 17, but you stated within the last 3.5 years. Can you give us the significance of those 3.5 years?
well, I knew of him when he was 17 through his stepmom. I did not know him personally. I got to know him personally in the last 3.5 years.
Understood. Based on your knowledge of Mr. Faust, do you believe that he poses a significant danger to the community or individuals in it?
No,
Why not?
like I said, in the last 3.5 years, as I know him, that he steers away from any conflict with people, and he likes to walk away.
Do you believe Mr. Faust poses a significant threat to intimidate any witnesses or interfere with the police's investigation?
No,
If granted or bond, no?
no,
How would you describe Mr. Faust's character as you know him to be?
he's kind, considerate, loyal, dependable, courteous to others, and trustworthy.
Now, you've given a lot of testimony to this on the report. I think the most important question that the court is always concerned about is witness credibility. If an unreported was to grant Mr. Faust a bond, would you be willing to sign Mr. Faust?
Yes,
Do you own property in this court?
yes,
And how much is your property worth? You know?
about $85,000.
If an unreported was to say, Ms. Thornton, I've heard everything that you said today. I'm going to sign this bond. Excuse me, I'm going to grant a bond. But I want you to sign, and I want you to put your property. Are you willing to put your property Court, I have one more question for you. The Honorable Court fashioned the bond order to state that Mr. Faust violates any condition of bond, including your property. Okay? Knowing that you could lose your wealth if Mr. Faust violates any condition of bond, are you still willing to sign the property up for Mr. Faust?
Yes.
I have no more questions for you.
Ms. Gonzalez, any questions for this witness?
Yes, Your Honor. Good morning, Ms. Stephanie.
Good morning.
My name is Deborah Gonzalez. I represent the state. In this case, I just have a few follow-up questions. You said that you are Mr. Faust's fiance. How long have you been together?
Well, we've been staying together for 2 years, but we was dating for 3 years.
For 3 years. Okay, would that take it back to 2021, 2020?
You have to say yes or no.
Oh, I'm sorry.
Yes.
Yes.
Okay. And do you guys live together? You said something about staying together, but do you live together?
Yes.
Okay. And how long have you been living together?
About 2 years.
About 2 years, okay. Did you know that Mr. Faust was arrested in November of 2022 for simple battery?
No.
Okay, but that would have been the time that you guys were together, correct?
Yes.
Okay. So you're saying that you did not know that he had been arrested?
I would object.
On what grounds?
I don't have a simple battery conviction from Mr. Faust, so I would say that putting matter into evidence unless you can show me where he has a 2022 conviction for simple battery.
I'm going to overrule the objection. She's got this witness on cross. You may follow up with this witness when she's finished.
Yes, ma'am.
Did you know he was arrested in 2022?
Not for simple battery, no.
Were you with him as dating with him in 2022?
Yes.
So it means that you did not know everything that was happening with your fiance?
Well, we wasn't probably staying the whole time of 2022 together.
Okay, so when
I wasn't his fiancée, you know.
I get it. So when were you his fiance then?
Well, we, probably last year.
Probably last year.
Yes,
Okay,
ma'am.
so not in
Sometime last year.
2022.
Yeah, when we was
but maybe
dating,
last
yes,
year.
yes.
Okay, and, you know, you spoke to the defense about how you have this property and it's worth $85,000.
Yes,
Is that most of your wealth
yes,
in that property?
yes,
And you're willing to sign it over for your fiance?
yes,
Are you willing to do anything for your fiance?
yes.
Thank you. No further questions, Your Honor.
Any redirect, Mr. Cruz?
Yes, listen, I have a couple of questions. If the Honorable Court was to sentence Mr. Faust to 24 hours house arrest with GPS monitoring, would you be okay with that?
Yes.
Are there any guns in your home?
No.
Does Mr. Faust have a passport to your knowledge?
No.
Okay. And are you confident that Mr. Faust will abide by all bond conditions?
Yes.
Okay. I'm going to ask you a question. I want you to really take your time and think about this question. The state asked you, would you do anything for Mr. Faust? Your response was yes. Can you explain that answer a little bit for us?
Well, I was saying I would do anything to support him as far as the bond and putting my property and stuff up.
Okay. So it's limited to that. You aren't saying, hey, I would do anything in the world for him. You're just saying for the limited purposes of this hearing.
Yes. Yes.
Thank you so much. I have no other questions.
Anything else, Ms. Gonzalez?
One last question. Ms. Thornton, do you love him?
Yes.
Thank you. No further questions, Your Honor.
Mr. Cruz, anything else? May this witness step down?
Yes, ma'am. No
You may step
questions.
down. Any other witnesses, Mr. Cruz?
I have no other witnesses, Your Honor. Just close.
All right. Go ahead.
Your Honor, the way I understand the law, here the preeminent issue is flightless. That's the way I understand it, and that's why I gave this under the Coleman case. I believe that's the 2012 case. I'm sorry, that's the November 2021 case that I provided to the court. The preeminent issue here is whether or not, if this honorable court gives Mr. Faust a bond, whether or not Mr. Faust will flee or return the bond. If the answer is that Mr. Faust will not flee, if we could fashion conditions to assure us that Mr. Faust will not flee who would appear in court, then we could address all the other factors, which are, if released, would he commit a felony? If released, would he be a danger or threat to the community or individuals in the community? If released, would he intimidate witnesses or interfere with the police's investigation of this offense? We're asking, Your Honor, we're begging. Mr. Faust is in custody, his life is crumbling. We are begging that the honorable court confines Mr. Faust to his home, and that's what we provided in the Brown case, 2012 case. We ask that he's confined to the home for 24 hours a day. We ask that he's only allowed to leave to visit me for medical, or we ask that he's allowed to work. And the reason we ask that, while Mr. Faust is in custody, although he has private counsel, over time, this case can take a year, this case can take 2 years, this can take 4 years. Mr. Faust becomes an indigent, and it impairs our ability to defend against these charges. Our court realized that our legislature is using things such as GPS monitoring and house arrest rather than in-custody treatment that Mr. Faust is currently enduring. What we propose for the honorable court in this case, and I gave on the court cases discussing excessive bond. One of the considerations is Mr. Faust's ability to pay. We ask that the honorable court set bond based on his presumption of innocence at $100,000 and require property as collateral. We ask for 24 hours house arrest. We ask for GPS monitoring. We can provide the address to the court. I don't want to say the address, at this time. We can provide address to the court. I have a company that is prepared to fit, because the honorable court will give Mr. Faust the money that is prepared to fit Mr. Faust with the ankle monitoring. They provide the DA's office with real-time tracking information. They provide updates every 2 weeks to whoever the DA's office would like for us to provide those updates to, or if I'm report one of those updates. And the DA's office can designate a person who can call and say, hey, we want to see everything that Mr. Edrick Faust is doing everywhere he's gone, and they will submit those records over to him. We ask that the honorable court, if there are concerns, impose upon pretrial supervision for police to call and check in. Anyone, I don't know if the probation officer does it here, but if they do, we ask for pretrial supervision for Mr. Faust as well. We ask for no visitors outside of the immediate family, as the testimony of Ms. Thornton that she provided. Mr. Faust's parents, unfortunately, are no longer with us. He has a daughter. We ask that his daughter is able to come visit. Ms. Thornton, she stays at home as fiancé. We ask for no other visitors. I believe this will satisfy the reasons under ideology, satisfy the conditions and concerns of pretrial release in this case. Regarding posing a danger to the community, commit felony, or intimidating witnesses, or interfering with the police's investigation. Your Honor, based on this record, I would ask this honorable court to permit me to answer any question that you may have.
All right, none at this time. Thank you, Mr. Cruz. Anything else, sir?
Yes, ma'am. I'd like to thank Mr. Faust for the privilege and the tremendous honor to stand beside him during this tough time in his life. I'd like to thank Your Honor for the time that you permitted today to present Mr. Faust's case. And I'd like to thank Your Honor for everything he does for everyone at all times. In closing, Your Honor, I've already given the honorable court a copy of the motion that we're objecting to any proffer from the state. I'm sure the state is aware of this. We provide the state with a copy as well. To any dealings where the state proffers that Mr. Faust committed absolutely any of these indicted offenses, as we want to obtain the evidence, we want to challenge this evidence, and we do not accept the evidence until we have a jury of our peers that's able to look over it, and we're able to look over it, Your Honor. And we rely on the case law that he is presumed innocent of any and all offenses at this time. Thank you, Your Honor.
All right, thank you, Mr. Cruz. Ms. Gonzalez.
Yes, thank you, Your Honor. I will just say the only witness we have here is a family member of the victim, and she would like to give a statement after the commissioner.
All right, go ahead.
First of all, Your Honor, the state is accusing the defendant, Mr. Faust, of entering the home of Tara Lee State, a young woman who was a first-year law student at UGA in her off-campus apartment that was located at 160 Dawn Drive in Athens, Georgia, on January 19th of 2001. The state is accusing Mr. Faust of violently attacking Ms. Baker, of sodomizing her, of strangulating her, of stabbing her in the neck, and of blunt force trauma to the head, causing her death, and then setting fire to her apartment to conceal the body as well as to conceal any extra evidence that there might have been of his wrongdoing. Your Honor, I will refer to the Ayala case that the defense did off because that is what we are here to discuss, the 4 factors of the Ayala case and whether Mr. Faust is eligible for bond under those factors. Factor number 1 is the severity of the crime. Again, the defense has laid out what those crimes are. 4 felony murder charges, 1 malice murder charge. We have aggravated assault. We have arson. We have rape. We have aggravated sodomy. These are all serious charges, Your Honor, and are at the very top level of severity of crimes that the state of Georgia has recognized. This is a heinous crime. It includes the strangulation, stabbing, and the blunt force trauma to the victim's head. The second Ayala factor is a flight risk. Your Honor, throughout his history, we have him in different locations, in different places, and even his fiancée was not sure about how long they had been living together, whether it was 2 years or 1 year. Number 3, the threat to the public. Your Honor, this defendant has a 49-cycle criminal history. He has violent offenses, and he has over 20 probation violations, which means that he has shown a pattern of disregard to the most basic conditions of being out of probation, and that is do not commit another crime. He has offenses such as aggravated assault in 2001, 15 days after Ms. Baker's assault. And in there, he was charged and convicted with slicing a victim's neck. He has a battery in 2011, terroristic threats in 2018, violation of a family protective order, and you saw the simple battery in 2020. For these reasons, Your Honor, we do find him a threat to the public. Which brings us to the last Ayala factor, the likelihood to reoffend and commit these future crimes. And there you see, 49 cycles in his criminal history. He was out on bond, Your Honor, when the murder of Tara Baker occurred. And so it is with the interest of justice and safety, Your Honor, for the community that the state does ask that, Your Honor, find the defendant a danger to the community and that you deny his bond. Thank you.
All right, thank you, Ms. Gonzalez. Before I hear from your witnesses, can you please give me a recitation of Mr. Faust's criminal history?
Yes, Your Honor. The criminal history begins in 1994, an underage possession of alcohol, 96, criminal trespass, 97, fleeing and eluding possession of firearm by convicted felon, carrying a concealed weapon. 1997, simple battery, criminal trespass, 97, robbery, 97, false name to law enforcement officer. 2000, theft by shoplifting, felony. 2001, parole violation conviction. 2001, aggravated assault. 2004, fleeing and eluding law enforcement officer. 2004, probation violation conviction. This is number 2. 2005, driving while license suspended. 2006, probation violation conviction again. 2007, public indecency and indecent exposure. 2007, driving while license suspended. 2011, DUI, alcohol, and battery. 2012, another driving while license suspended. 3 of them in that year. 2012, we have 3 probation violation convictions, followed by 1 in 2013. 2013, willful obstruction of law enforcement officer in possession of cocaine. Another 2013, possession of cocaine with intent to distribute conviction. 2014, probation violation, 2 convictions there. 2014, driving while license suspended, revoked 4th or more. That's a felony. 2015, 3 probation violation convictions. 2016, willful obstruction of law enforcement officer. 2016, we had 3 more probation violation convictions. 2016, DUI alcohol, hit and run, driving while license suspended. 2018, another probation violation conviction. 2018 also is when we have terroristic threats and a second probation violation conviction. 2019, driving while license suspended. 2019, probation violation conviction, 2 of those, Your Honor. 2019, willful obstruction of law enforcement officer. 2019, harassing phone calls, violation of family violence order. 2019, 3 more probation violation convictions. 2020, 2 more probation violations. 2021, 2 more probation violation convictions, which brings us to 2022, our criminal trespass and simple battery. There is a pending charge in Oglethorpe County, Your Honor, from 22, a DUI alcohol, and then our charges here in 2024.
Thank you. All right. Anything else from the state? Any witnesses you want me to hear from?
Yes, I would like to call Meredith Baker, Your Honor.
All right. You may swear her in.
Can you please raise your right hands? Do you solemnly swear or affirm that the testimony you give this court is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you so much. May you please state and spell your name for the record?
Yes, ma'am. I'm very sorry. It's Meredith, M-E-R-E-D-I-T-H, Baker, B-A-K-E-R, Schroeder, S-C-H-R-O-E-D-E-R.
Thank you. And who are you in relation to Tara Baker?
I'm her sister.
Thank you. And you had a statement that you wanted the court to hear.
Yes, ma'am, if that's okay.
May you please proceed?
Well, as we already stated, I'm Meredith Baker Schroeder, and I am Tara's sister, and I'd like to thank Your Honor for the opportunity to speak on behalf of my family. January 19th, 2001 was, by no stretch of the imagination, the darkest day of our lives. As we made the 90-mile journey to Athens that night, we had no idea what lay in wait for us. Believing that Tara's death was an accident, it wasn't until we were sat down by police that we were told that foul play was involved. That night, our lives were shattered, our childhoods abruptly ended, and although we have learned to breathe, walk, and live with gaping wounds in our souls, we are not the same people that woke that January morning. We have strived to keep going and to live the life that was denied Tara. While she was only 23, she had already set the bar so high that it is yet to be reached. Now today we face a defendant who is allegedly responsible for the heinous crimes committed against our Tara, for cutting her precious, promising life short. We've waited 23 years for an arrest and an indictment, and within those 12 counts, we learned just how horrific and harrowing Tara's last moments were. Since the arrest, I've done my due diligence, and I've learned how this defendant has lived these past 23 years without any regard for the law that Tara was hoping to one day represent. This defendant has been no stranger.
Objection, Your Honor.
What's your objection?
The Crime Victim Bill Act allows her to discuss how this has impacted her. She cannot make comments about Mr. Faust.
I'm going to overrule your objection. You may continue.
Your Honor. This defendant has been no stranger to this very courthouse or the surrounding counties for that matter. For 30 years, he has wreaked havoc on this community. He put a knife in a man's neck just a few months following Tara's death. He gave a false name to police. He was arrested for criminal trespass.
Objection, Your Honor, is the same objection. She cannot attack Mr. Faust under the Crime Victims Bill Act. She can discuss how it affects her. She cannot attack him on the stairs.
Okay. I'm going to overrule your objection and make a comment that anything the witnesses say is not to be considered as evidence at this point. You may continue.
Thank you, Your Honor. He was arrested for criminal trespass, battery, assault, fleeing police, distributing narcotics, harassment, stalking, and a lost count of all his parole violations. This defendant cannot go to Waffle House without throwing a tantrum, nor the 40 Watt without breaking a man's jaw, nor cruise without being arrested for domestic violence. At least we forget that he is barred from UGA for indecent exposure. Your Honor, the defendant stood before you in 2019 for violation of a TPO granted by Judge Stevens for aggravated stalking and harassing phone calls of his ex-wife. In that bond hearing, you noted, that this court finds that the defendant possesses a significant risk of committing future felonies and is a significant risk of intimidating witnesses. Given the reason that we are here today, I don't see how that previous statement can be any less true. Thank you, Your Honor.
Any further questions of this witness, Ms. Gonzalez?
No further questions, Your Honor.
Mr. Cruz?
Just a minute.
Go ahead.
First and foremost, I want to say that I'm tremendously sorry for your loss. I just have a couple of questions for you, if that's okay.
Sure.
The statement that you provided us on the report regarding the impact that this has had,
Yes, sir.
that would apply to anybody that would be sitting in that seat. Is that correct?
That is correct.
And at this time, you don't know whether or not Mr. Faust is actually the person that has done anything to your sister. Is that correct?
That is correct.
Thank you.
Anything else of this witness, Ms. Gonzalez?
No, Your Honor.
All right, you may step down. Any further witnesses, Ms. Gonzalez?
No, Your Honor.
Any further argument?
No further argument. Your
Mr.
Honor.
Cruz, this is your motion, you have the last word.
Your Honor, the Ayala case provides that it is the defendant's initial burden to put forth evidence relating to all the Ayala factors. Once the defendant does so, the state, by a preponderance of the evidence, must show that the defendant is not entitled to bond because the defendant is either a flight risk or the defendant is a danger to the community. Your Honor, at the bench review, I filed a motion objecting to the state's proffer of evidence. The state has presented no evidence on the issues related to this bond. Mr. Faust has presented evidence of his ties to the community. He's had witnesses testify that he is not, he could not flee, and he's had witnesses testify that he's not a threat to the community, a threat to commit a felony, a threat to persons in the community, or poses a risk to intimidate witnesses or interfere with the police investigation. I ask, Your Honor, that you grant Mr. Faust a bond. He's presented evidence on his behalf. The state has presented no competent evidence. And we have case law, provided you case law, and attorney property is not evidence if opposing counsel objects and requires the state to put up evidence via witnesses or competent evidence, and that just wasn't done today. So, Mr. Faust is entitled to a bond. I would ask that you grant the bond as requested. Your Honor, thank you so much for your time.
Thank you, Mr. Cruz. 4 factors in determining whether an accused is to be granted bond. The 4 factors are these: whether a defendant poses a significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required. The state has not presented evidence with regard to that factor. Number 2, whether the defendant poses a significant threat or danger to any person, to the community, or to any property in the community. The state, by proffer, has indicated some of the evidence that they have. And based on that evidence, it is clear to this court that the way in which the state has alleged these crimes happened show this court that this defendant, at this time, poses a significant threat to persons in the community. The 3rd factor is whether the defendant poses a significant risk of committing any felony pending trial. The state has presented evidence with regard to the felony record of Mr. Faust. The felony record that the state has presented includes the years 1997, several convictions from 2000, several convictions from 2001, 2013, 2015, and 2018. The court finds that that evidence is sufficient to show this court that this defendant poses a significant risk of committing any felony pending trial. And the last factor that the court must consider is whether this defendant poses a significant risk of intimidating witnesses or otherwise obstructing the administration of justice. The state has not presented evidence with regard to that factor. But based on the evidence that the state has presented with regard to the proffer with regard to count 2 and the evidence with regard to count 3, I'm going to deny bond. Mr. Faust, you need to stay in touch with Mr. Cruz. Ms. Gonzalez, I have given Mr. Cruz 30 days to file motions. Typically, obviously, it's 10 days by statute. I'm going to ask the state to make sure that it presents a witness list to Mr. Cruz within 30 days. And Mr. Cruz, if you file a motion for discovery, Ms. Gonzalez, you're on notice that that motion, I'm sure, is coming. And if you'll provide discovery and access to it as soon as possible.
Yes, Your Honor, just to give you an update on that, I did receive a discovery motion.
Okay, I don't have it. All right.
He is going through the process
Okay.
to get access electronically.
All right, thank you. All right, court is adjourned in this case. Thank you.
Guys, they just stay seated for just a
Everybody
moment,
up to main
please.
seat, please.
All right, we're going to go back to our regular calendar and take care of the cases we don't want. Any of the private counsel who came in after we finished our morning, whose case I have not closed. All right, we're going to go back to the arraignment calendar.